All right, I've called to order the Sunshine Ordinance Task Force Compliance and Amendments Committee special meeting for Tuesday, March 3rd, 2010. Roll call, please.
Yes, Madam Chair. Member Craven Green.
Excuse me. Wednesday, March 3rd. Sorry, roll call, please.
Member Craven Green.
Here.
Craven Green present. Member Johnson. Here. Johnson present. Member Nee.
Here.
Nee present. Member Washburn.
Here.
Washburn present. Member Goldman. Member Goldman excused. Madam Chair, we have a quorum.
Thank you. The way I propose that we'll start this process is by going through the edits that I suggested to Articles 3 and 4, and then what I would do is, there's two members of the public here. I think we'll try it this way. If a member of the public has a comment or suggestion or wants to make public comment on one of the items that we're talking about, just stand up and get my attention and you'll be recognized for that item. So we'll just proceed through, and when we get to a point where a member of the public wants to comment, that will be taken. So turning to the first item of business is just, I had submitted to Chris basically revisions to the title pages which need to be made. So we don't really need to discuss them. They just make it consistent with the revisions that we've made to the underlying titles in the headings and the order of them. So Chris, if you just please, we'll go ahead and make those. There shouldn't be any
Yes, Madam Chair.
controversy about that. Turning to first 6720, which is new 6720, which is process for gaining access to public records information, administrative appeals. 6720A on line 6. It should be page 47 of the document that Chris mailed out. There needs to be an S for requests. Do you see that, Chris?
Which page is it, Madam Chair?
47.
47.
Line 6.
Line 6.
Requests, plural. New 67C4. We need, and this is page 48, line 17. It should read time, place, and requester by the department, comma, policy body, or custodian of record. Custodian of records. (6720E), line 10. This is page 49. In the second, on line 10, we should remove city attorney and insert instead department, policy body, or custodian of record. New 6720F on page 49 as well. Going over to page 50, supervisor of records should be capitalized on line 18. And line 22, thank you.
Sorry, Erica, did you
Yeah.
want us to interrupt you?
Yeah, sorry, I didn't look up, I apologize.
Okay. I actually have a substantive comment on F, the one you're just talking about.
Okay, let's just finish my suggestions,
Oh, sure.
and then we'll take comments on 6720F. Thank you for, yeah, please, if I'm not looking up, just interrupt. The other suggestion is the second sentence should read, "The supervisor records shall inform the petitioner as soon as possible, but no later than 10 calendar days after a petition is filed of its determination." So we're making it clear that this is this, page 49, Chris, line 18, that sentence that starts with supervisor of public records. Okay? So it should read, "The supervisor of public records shall inform the petitioner as soon as possible, but no later than 10 calendar days after a petition is filed, of its determination." Because there was some debate about how that 10 days went, and whether it was working days or calendar days. And then the final sentence of that section, which is on page 50, line 6, should read, to make it consistent with other provisions in the ordinance, "The supervisor of public records shall copy the Sunshine Commission on all determinations of actions on petitions under this subsection." Determinations or actions, not of, determinations or actions. Yeah, the last sentence, right now, it provides, "The supervisor of records shall copy all correspondence pertaining to its duties under the subsection to the Sunshine Commission's public review file." We had felt that that was too extensive. We didn't need to see every single communication, but what we thought was important and should be copied to the Sunshine Commission is all records of all determinations or actions on petitions. So if they dismiss it, if they make a determination on it, that's what we want to know. We don't necessarily need to know the back and forth between the requester. And that is consistent with a prior revision that we made in Article 2. So that's it for 6720F for me. I'd invite comment from Mr. Grossman.
Yeah. Since most of you haven't had the opportunity or the pleasure to deal with the supervisor of records, you probably don't know exactly how that office operates. So one of the problems is that it is not clear enough that it's independent of the city attorney's office with respect to certain views it holds on subjects which are controversial, so like the issue of calendars, whether it's the Prop G calendar or the real calendar. As a result, Paula Jessen has often adopted the views of the city attorney when reviewing these requests related to custodians who won't turn over records. So the issue of her, I say her because it's been Paula Jessen for the last, I don't know, year or so, year and a half, is how independent is that office supposed to be? My impression was you go to the supervisor of records because that's an independent office. You don't have to make a formal complaint as you would and follow the whole procedure that is involved before the task force. But it generally results in very little satisfaction. And I don't think it's used enough probably by some of the people who are active because they know it's a now Chemo does it and Christian Homer for his, whatever, and he does get some action out of her, but I still think in those cases where there's a controversy involved as to whether a record should be disclosed or not, whether it's exempt, that office should be independent of the city attorney's office because, it seems to be the right thing. That would be my comment.
Thank you. Are there any other comments on 6720F or 6720 in general?
Yes. Peter Warfield, Library Users Association. I received an invitation from Mr. Nee about this meeting, for which I thank him and I'm grateful. Unfortunately, the invitation came March 1st, and I saw it March 2nd, and so for 100 and something pages, plus trying to figure out what it is that's attempted to be accomplished here, there's been very little notice. I have said repeatedly to this body over the years that you have seemed to bend over backwards to solicit departments, which happened in a previous round, for what they would like. You have had a meeting of the Education Outreach and Training Department for live meetings of what departments thought, and they were given essentially unlimited time and space in that meeting and in that solicitation. But never, to my knowledge, has the public been invited on an equal basis to participate and contribute its thoughts on overall or these specific changes, nor to make comment on their problems or what's effective about the ordinance. So I'm not staying here. I don't have time today. I wish that you would allow an extended period for members of the public, as well as an invitation to the public. And I'm very troubled that this has not occurred despite multiple requests over time. To go dit by dit, when somebody like myself or anybody with experience may have a particular problem or a particular concern or a particular suggestion that may cover multiple sections, I think you've just never allowed that and never had that possibility. A person has to have the patience of Job to sit through and go through all this stuff. As an example, I was recently recommended to somebody as an expert in the cost of copies, because how many places in this ordinance does the cost of a copy come up? I couldn't even tell you. 2, 3, 4, 5 times? You tell me. It's never consistent. It's never clear. I've had a complaint that was successful with respect to a public, the cost of a copy, because this body was charging me through its administrator 10 times the allowable amount. The Sunshine Task Force agreed with me, and then the clerk twisted the interpretation and said, well, if you are on the subscription list for copies, then you can get it for the penny a page. But if the day after the meeting you request a copy of the agenda packet, 10 cents a page. Complete nonsense. But I wasn't up to filing yet another complaint about the cost of copies and how and why and what the interpretation should be. With respect to this, I can only say, and the insidiousness of that beep is appalling as well. There's only 2 people here who have huge experience, and to cut them off is, again, completely unnecessary and inappropriate, especially when I've said I'm going to leave. So if I may make a few more comments on this,
Yes,
I'd be
you may.
glad to. Thank you. One of your other sections, by the way, says something about public comment, and it says people should be allowed 1 opportunity comment for a minimum of 3 minutes. The minimum part is a good change. It should say at least 1 public comment. There's nothing in practice or in the law that says you can't ask or have somebody come up again to clarify, expand, or talk again or answer a question. And there's no reason why you couldn't even have people do it twice. So now that you're giving me an additional, 3 minutes, fine. You can do that. It's within your purview, and I thank you for doing it. That section should reflect that and not make it sound as though people only have 1 single chance. But many of these changes have huge impacts, and they may not be so obvious, but having not solicited people, and I don't think you'll have any clue. And you should allow people to say, what have I found to be a problem? And tell an anecdote that may cover a section that you don't even know exists or doesn't exist, or that may involve interpretations of 1 or more sections that you never heard of before. And I've got plenty of stories, but you've never asked for them. You've never solicited me, nor anybody else that I know of, to specifically say what's working, what's not working, and what would they like. With respect to this as an example, the custodian of records is a very tricky business, because certainly folks like the Library Commission have tricked out so that people are fooled by the original concept. The original concept said every person in Section A, every person having custody of any public record or public information is a custodian of public records. And that's somebody that you can go to. If I go, as I did with a colleague on the Library Citizens Advisory Committee, to a branch on a Saturday, and we ask, what are the circulation figures that are published every month by the library for all the different locations? The librarian gave us a copy to look at. When my colleague said, do you suppose we could have a copy? The branch manager freaked out or got cold feet, whatever you like, and said, well, I'd rather you asked the chief of branches in the main office. She didn't even tell us who he was or what his phone number was. Okay, fine. That means that instead of making a copy of one page while we're there on a Saturday, she's going to put us to the trouble, and I didn't get involved, but my colleague did. It took her weeks before she figured it out and got it up to doing it and so on and so forth. The custodian of records is anybody who has a record or has access to a record, and if I ask you, could you print out, please, the copy of the circulation records for system-wide, it's a one page, there should be no question that that person that I've contacted at a branch on a Saturday has absolutely the requirement to do it and to do it promptly. Instead of this rigmarole of all going through a single custodian, which is a very corporate thing and essentially allows, as an example, the Secretary of the Library Commission to have the title given to her by the schemers there of Custodian of Public Records. So when I ask her about RFID, which the tech services people know about, she has no clue. And why should she? When I ask about something to do with the ordering of out-of-print materials, she has no clue. And it guarantees, as in an hourglass, that it's always going to go through a person who has no clue what I'm asking and no clue what the answer is. So she's going to repeat my question and go to somebody to get an answer, then get an answer she has no comprehension of, and then pass it along to me. And I have to go and ask her, well, what exactly did so-and-so, who answered this? What does it mean? I don't know. And that's not anything bad against the Secretary of the Library Commission. It's against what the library has done to twist and distort the concept of a custodian of public records. And for your body here on item A to make it seem that there's one custodian of records in a department is an abomination. It should stay the way it is, perhaps with clarification. Everybody who has a record is obligated to show it and to make copies without unnecessary delay. And it should be very clear that if I want to talk to the head of technical services who knows all about the ordering of out-of-print materials, or whoever it is, that I have the right to speak to that person, and they have the obligation within reason to give me a straightforward, simple answer. And the library has repeatedly managed to extend out to the maximum length possible the simplest question by instructing people to say, don't talk to him. Oh, yeah, it's different if you call or if a press person calls. But if I call and I want to talk to, that has to, please make a request, please make an immediate disclosure request to the custodian of records. And now I have to write instead of ask or fight it out with a complaint to Sunshine. And now I have to make a formal request through writing, through email or something, mail it, email it, and now I have to go and wait for the secretary to get it and to then pass it along to somebody who then presumably might answer it and so on. And the easy exchange that you routinely expect from somebody who knows what's what is smashed by that formalizing of the requests and the formalization of a custodian as one single person, as I said, like in an hourglass, the skinny part, where it's always going to pass through somebody who has no clue and no expertise, except maybe by chance. So this is a disaster to corporatize in one person. And let me say another thing. I believe that the reason they do it is also to coordinate the lies, to coordinate and make consistent the responses so that if I ask this one and then that one and I get inconsistent responses and want to look further in a normal procedure, that's going to be closed because everyone's been instructed to clam up, say nothing, instruct that person to go to the custodian of records. And that is not open government, and that's not Sunshine at all. I wish, as I said, that you would allow people as extended a time, certainly people with a lot of experience, and not to go dit, which I also appreciate. But for somebody who wants to say there's 5 different places, and I can't tell you, I'm the expert according to somebody else who's an expert, but I can't tell you where it is. I can tell you some of the different things about the price of a copy, and my sad experience, even, quote, winning, unquote, a case. But I don't want to go into necessarily all the details. I'd like a consistent statement of what does it cost for a copy. For example, there's no statement here, how fast do I get a copy? Aren't those games we've played? I have never gotten from the library a copy that I requested on the same day. And I can tell you an anecdote that indicated they have a double secret rule. Never give him a copy on the same day. Make him come back another day. A receipt for money that I've given them? Oh yes, all of a sudden their fax machine is also a copy machine. Here's your copy. 1 minute after I've paid some money and they want to give me a receipt. But do I ask for 1 page of something? Never, never have I gotten it on the same day. So copies are a big game. How about the cost of having something copied? I can tell you an anecdote. I'd love to tell you these stories, how the foundation of a cost and a charge is multiplied into 16 different ways to delay and obstruct a person who actually had, in that case, the exact change of 80 cents for the 8 copies that I wanted at 5 minutes past 5. And I can tell you why I was forced to come back, even though they normally work until 6 there at that time. I'd love to tell you the story and give you a real life some real-life examples of which certainly I've had plenty, but I do think that you need to invite people, you need to give them extended time, and you need to explain to them also what you're doing. I mean, from this 100 and some pages, I couldn't even understand whether this is only through '08 or whether this is the current changes. I have no idea when I see the table of contents what it is that Ms. Craven wants to change or why. I see the disappearance of certain sections like immediacy of response. It's crossed out. I'm saying, well, surely that hasn't been dropped, and there's nothing that says where to find it. No, it's several sections. It's several sections up. But where my eye fell on the deletion, there was no mention that 5 sections up, it's been inserted over there. So I mean, I've done this before on a whole round of changes with the Sunshine Ordinance several years back, and I went to every meeting and so on and so forth, and I said then at the time that it was a nightmare. You need to go and find technical writing manuals or something that gives you basic version control, marking of changes, and an explanation overall of what the strategy is. You know, here we deleted this section. No, it didn't disappear. We moved it 5 sections down, and an explanatory note perhaps in the margin. But somebody looking at that is saying, what? You got rid of immediacy of response? And again, there may be problems you're dealing with that I'm not familiar with, but to say what it's trying to solve would be very helpful. To say where it's gone would be helpful. To say generally what is being enhanced would be helpful. And certainly soliciting people who've had a lot of experience would be very helpful in giving them a chance to just say freehand what they like. Thanks very much.
Thank you. I think because Mr. Warfield's planning to leave, we'll just briefly discuss his concerns first. With respect to process and invitations, our agendas have clearly noted where we're discussing different articles, and everyone's been invited to come or submit comments. So we have had an open process. If someone has additional comments or anecdotes that they would like to submit, I would encourage them to do that in writing as soon as possible. After the amendments get approved here, they will go for a special meeting, I suspect, a full task force. So those comments and concerns need to be on the record as soon as possible, and certainly included before the full membership when they get to vote on these amendments. So I do believe there's been notice and encouragement of people to participate. And I know Mr. Grossman, for example, has done a lot of participation about a year and a half ago, and we've taken that very seriously and have appreciated that. With respect to cost of copies, it has been, there's been an attempt to consolidate that in the ordinance and make it clear. If Mr. Warfield would like to read those particular amendments and give us comments, if he doesn't feel it does the job, to suggest specific language on how to improve it or how to further consolidate it, I would appreciate that, but we have attempted to do that in the ordinance. I believe Mr. Warfield has already testified once before on the custodian of records suggested changes. When this first was conceived of, you were here, Mr. Warfield, and you said you didn't like the concept, and you expressed the interests. So again, you've had an opportunity. That language has remained in there. We felt it was important that departments have someone designated as a custodian of records. Most departments would say, oh, well, it's not our fault, we didn't respond to the public records request, it got shuffled in the mix, it wasn't responded to. This requires them to designate someone who is going to have the responsibility of meeting these deadlines. And if they don't, they're going to have the responsibility of explaining why not and being held liable for not doing so. With respect to individuals who have public records, any individual, it's still clear in the ordinance that has public record is required to produce it if they have it. An individual who has oral information in the oral information section is still required to respond to informal contacts that aren't disruptive to that person's work. So those concerns those issues have not been changed. There's still that requirement in this ordinance, despite the nominating of a custodian of records by each department. So I hear your concerns. I think we've addressed them. To some degree, we disagree. But your major concerns are, in my view, addressed by the existing language. It's in there. Those requirements are in there. Better tracking and cover summary, I agree. We're trying to do our best. We have annotated to the best we can so far of where things have been changed, so someone reviewing it can see, oh, immediacy of response hasn't been deleted. It's just been moved up 4 sections. So we are doing our best. We'll continue to do that and to do a cover summary. That's another thing that we have to do. With respect to the supervisor, to Mr. Grossman's comments, I think, with respect to the supervisor of records, I think that's an interesting point. It's not something that we've considered amending or requiring, that the supervisor of records be someone independent within the city attorney's office. My own personal view is that the idea behind the supervisor of records provision and the supervisor of public forums, which is the compatriot or other side of the coin that we've also created in these amendments, is that there should be someone in the city attorney's office to whom members of the public can go to and get a decision on these issues without having to file a complaint before this body. That's a very unique situation. Members of the public usually aren't entitled to go to the city attorney's office to get a legal opinion on a matter of government policy. But with respect to open government, they are, because of this provision. From my perspective, I'm not surprised that the supervisor of public records tends to agree with someone else in the city attorney's office who happens to be advising clients. I think that's not surprising. I think that is the nature of the situation. I'm not sure that we can mandate, other than mandating that the supervisor of records be an outside attorney, someone not within the city attorney's office, or to be walled off ethically from the rest of the city attorney's office as the task force's district attorney, or deputy city attorney, excuse me, is. I don't see a way around it, and I personally don't see a need to mandate either of those 2 other options. I think it's a process. It may not work in every situation because from a complainant's perspective, they may simply agree with the attorney advising the department, but in other situations, it has allowed for production of documents. It has gotten the attention of departments who've responded to the requests, and it has allowed the supervisor of records to look at documents in camera where we hadn't had the power to do so, and in many situations, release additional information to the complainant. So I don't think it's perfect. I think it's got the problem that you've identified, but I don't see a necessity at this point to try to address it, because to do so, I think, would cause more harm than good, or would require more expenditures, which I don't think needs to be done at this time.
Okay, can I
Yeah.
just simply say one thing?
Yeah, why don't you take a few minutes to respond?
I just want to respond to that, because I think there's a way to deal with it. And that is, there are a number of issues where the city attorney and this body do not agree. okay? PDF copies, you know, the famous Zarefsky memorandum. Paula Jessen, as I recall, still follows the Zarefsky rule. You've ruled against it. It's gone all the way to the Board of Supervisors, and yet the Supervisor of Records is still willing to adopt a policy that has been basically tossed, okay? Why? Same with the issue on calendars. That's come up 2 or 3 times now, and each time you've gone as far as you can go, send it over to ethics, and we know what they did with it. Okay. And the thing with ethics, I'm just going to segue off a second, is under their MO, if a city department or an individual follows the advice of the city attorney, they can never, ever be further, there's no enforcement against them. Your referral is dismissed, period, end of story. The thing about the supervisor of records is you can make clear 2 things. One is that the standard is independence. They don't have to be a separate lawyer from the outside. Just say that it will be an independent and unbiased, you know, view of the law, and it will take into account decisions made by the task force. If that's the case, then the Zarefsky stuff will go away, the calendar stuff will go away, and then it'll really be where it belongs, which is another alternative to the expensive process of going to the task force and through that whole thing, ending up with ethics or someplace else, and you're still, you know, or in court, as I did. So I just think that you could say it a little bit stronger and more articulated in the sense of independence and following the prior rulings of the task force. Thank you.
Thank you. Yes, Mr. Warfield, if you would like to have 3 minutes to further comment, I would welcome that. And then we'll move on.
Thanks very much. Appreciate that from the chair. One of the things that's happened in a range of places, certainly at the Library Commission and even here, is we get a recitation from the city attorney. You don't have to answer question. This is not a place for a dialogue. Well, why not? Why not? You've got people out here with a tremendous amount of experience, certainly more experience than some of you, and different experiences from which you might gain, and for that matter, I might. With respect to the chair's mentioning of people being solicited through agendas, well, of course, I appreciate that, but I'm referring to a specific meeting of the Education Outreach and Training Committee that was chaired by Mr. Pilpel, in which he invited people from departments basically to come and make presentations with no limit of time that I was aware of, and basically trash the people that were hassling them with requests. This went on at length, and then the members of the public, hey, got 3 minutes to respond to a whole range of claims, accusations, etc. That was not an equal or a fair hearing. Furthermore, in a previous round of changes, this body solicited the Board of Supervisors and departments, and then for months had a spreadsheet of departmental wishes and desires and suggestions, etc., traveling with each agenda so that you could deal with what the departments wanted. Now, I'm not saying you should never solicit departments to come and speak, nor am I saying you should never solicit departments to provide you with material. What I am saying is that I would like the public to get the same invitation and the same treatment and the same, if you like, standing, so that these things will be visible as they were with the department document that traveled around. And the invitation, I would suggest, would be very useful to be extended to people who've complained and people who've contacted the administrator, because there are a lot of people who have a lot of experience. I don't know all of it. I've had certain experiences. And so I think you would gain a tremendous amount from people, and especially the ones that don't keep coming back, because many of them may have problems with your determinations, problems with your procedures, that you would be well to listen to. Finally, let me just say I appreciate having quickly seen this and not have, again, sufficient time, but under Section 6723, under public employee having a duty to respond to inquiries from the public, that is tremendously important, and I think that should have a separate section of its own, because so often people are told, you don't talk to me, go and make an immediate disclosure request or a public records request. And the simplest things that in normal intercourse you can ask, like, does the task force have a schedule of meetings? Or is it going to come up soon? Things that somebody would know in their head, or things that might require pounds of documentation to summarize, like, for example, what you know about your changes. It should be appropriate to say, Madam Chair, what are the major points that you're trying to accomplish with these changes, and to get an answer. And I think that that's tremendously important when when departments try and shut down inquiries. That's one of the first things they do. They instruct everybody, no response to either such and such group or people or individual or even anybody. And so Section 2067, new number 23B, I think is on the right road, and I appreciate that. But it needs to be a separation of the official person, who in the past was somebody you went to if you didn't know who to ask, versus everybody else in the organization who you should be entitled. I should be able to say to the library, who's responsible for ordering out-of-print materials? And then I should be able to call that person and say, what's the procedure for ordering out-of-print materials? Or do you have one? Or do you have a policy against doing it altogether, which the library sadly did? And that should be a real simple thing. And the time limits, which are later described, I think maybe need to be sharpened a little bit, because probably anybody could say it's going to take me longer than 15 minutes. But I personally would certainly be happy with an answer sometimes of 3 minutes, at least to get me going on where am I and what is the general policy of the department. So again, I encourage your improvement efforts, and Section B, which has an underlining, is an improvement because it never was clear. It sort of was roundabout about the 15 minutes, but I think if that could be made much more explicit, it would be tremendously valuable to the public. Thank you.
Thank you. Member Washburn.
I'm still thinking about Mr. Grossman's suggestion about the supervisor of records, wondering, is it possible to insert a clause showing that this person should be independent and unbiased without causing the problems you mentioned earlier?
I mean, I don't, my personal perspective is I don't know what that means. They should be independent and unbiased. I mean, independent and unbiased towards what?
Right. I realize that it'll take more than a clause probably, but.
I mean, to me, I don't see it. Unless we are creating a separate body that's independent of the city attorney's office, i.e. not within the city attorney's office, or someone who is ethically walled off from the city attorney's office, I don't see a way around the problem that Mr. Grossman has identified. I don't think by putting in a clause that says they should be independent and unbiased, that helps.
No, I see what you mean, but nothing like that they're ethically walled off. This person could be ethically walled off, as is our deputy city attorney.
See, my perspective on that is that's actually not helpful, and that would actually defeat the purpose of this provision. I mean, what the purpose of this provision is that someone can go to the city attorney's office and say, you know, hey, I've asked for this record, I haven't gotten it back, I really think it's a public record. What do you think, city attorney's office? What do you think, supervisor of records? And so I think it's actually helpful for the supervisor of records to talk to the department or talk to the other city attorney that's advising the department and say, why haven't you given them this record? What's going on? The fact that the supervisor of records would ultimately agree with that person, the deputy city attorney advising the department, I don't think is wrong as a matter of course. Is it frustrating when the supervisor of records disagrees with us? Yes. Do I think there, especially the two examples Mr. Grossman said, do I think that those examples, supervisor of records adopting the Zarefsky memo and adopting the Prop G calendar as the ceiling of what is to be released. I, as a private attorney, would love to take on those two cases and believe I would get my attorney's fees because I would win on both of them. So I'm not happy with that, but I just think that's going to happen with the supervisor of public records because the purpose of it is to allow people to go to the city attorney's office and get the view of the city attorney. If we wall them off, then what we're saying is you can't go to the city attorney's office, really, but you can go to this one person. And who is that one person? Is it someone who's also does code enforcement work, who doesn't have experience in open government? I just think that that idea is a bad one. I think that it's better to have a supervisor of public records that does communicate with people in the office and is, in fact, the voice of the city attorney on these issues for someone who doesn't want to come through us, but wants to go directly to the city attorney's office. I think that's the purpose of it.
So this person, I'm sorry.
Yeah.
So the supervisor of records is bound by the city attorney's opinions, and this person could not disagree with the city attorney based on her understanding of the Sunshine Ordinance.
Well, it depends on who you mean by the city attorney's opinion. But say, for example, the city attorney the city attorney, Dennis Herrera, has issued a city attorney's opinion on something which is on the website.
Mm-hmm.
Yes, that the supervisor of records, who is a deputy city attorney in that office, is not going to disagree with the city attorney's
Right.
opinion. I don't think they should. I don't see a problem with that. They're in that office. They're a city attorney. That's what they do. Okay? I mean, that's who they are. That's the function of that office, is to give the city attorney's position on an open government issue, right? Now, if the question is, say there's no formal opinion from the city attorney's office, right? But there's been advice given by a deputy city attorney who advises the Ethics Commission on whether or not they should release investigatory files, for example.
Mm-hmm.
And someone goes to the supervisor of records and say, I want to know whether or not I can get access to the investigatory files of the Ethics Commission. I think it's a matter of policy, it's a matter of practice of how this is supposed to operate. That person can go and talk to their colleague and say, well, why did you say that? And why did you say this? And that person can, make a decision that agrees with them or that disagrees with them. And that then states what would be the new city attorney's policy, right? If the supervisor of records is saying X, that to me would seem to be, evidence of what the city attorney's policy is, even if there's not a formal opinion.
Okay, what about the cases in which the supervisor of records knows that the Sunshine Ordinance Task Force has ruled in a particular way and it happens to be at odds with the city attorney's office? I guess in my perfect world, the supervisor of records would let the member of the public know that there is a disagreement here, so the member of the public would be informed about, you might want to take this to the task force. Otherwise, the person may not know that our body has a different and more, stringent rule. I guess that's what I mean by independence. I don't know if that's what Mr. Grossman was getting at either, but
Well, I think it would be good practice if the supervisor of public records would say, oh, well, the task force may have said X or Y, or even though I believe it's Z. But, if you want to include that in the language, then suggest some new language that would include that. I don't see that as necessary, but if you would like to suggest some language, then let's do it. But otherwise, let's not.
I'm really just, kind of thinking
yeah,
off the top
yeah.
of my head. I'm listening to what Mr. Grossman
Right.
said. I do see a problem. I try, in the interest of having the public be fully informed about what his or her options are, being apprised of a conflict, an ongoing conflict between our body and the city attorney's office would be, I think, a useful thing. Otherwise, it's a way to keep moving on having a government be as open and transparent as possible. I don't know if somebody else wants to help me out here. But
Well, the
that's what
problem
I'm
with that, we have to adjourn momentarily and go to a different room. Apparently, we lost this room. We have to go back next door. But before, let's just.
Can I just give you about
Can you come with us to the next room, Mr.
Sure,
Grossman?
sure.
Yeah, we'll address this to the next on the record. We're back in session. I was going to make a comment, and then I was going to invite Mr. Grossman to respond again. It's a very interesting issue. My comment to Ms. Washburn is, once we start mandating how this person does their job and what they consider and what they cannot consider, we just start getting, it just starts getting into, in my view, not micromanaging, but bad legislation, right? Supervisor of records must consider this, must not consider that. It's different than our enforcement proceedings, where we can set out what standards we want to apply. I mean, to me, the benefit of his office is that it is a way of individuals to get information or a decision from the city attorney's office. That's who we're asking for it. That's who it is. And so I think by saying, oh, and the city attorney can't disagree with the task force, or has to defer to the task force, it undermines the utility of it. It's supposed to be not the task force, but the city attorney's office. So I see the problem. As I said, I was frustrated when they disagree. Very frustrated. But I don't think we can I don't think it's wise to legislate it differently. So that's my opinion. Mr. Nee, did you want to talk? Or you want to hear from Mr. Grossman first?
No, I was gonna talk, but I think what you just said kind of answers the questions that I had. So I'm perfectly happy to hear from Mr. Grossman.
Okay, well, the thing is, most departments will honor a records request. It's really only in the touchy areas where there's something they really don't want you to see that the requester has to find a place to go to get some relief, to get a remedy. So what are the choices? Starting with the most difficult, which is filing a lawsuit. Having done it, and how long it took me to find someone who really wanted to take it was a chore, and I did a lot of preparation. Okay. The second possibility is to come before the task force. You got to file a complaint, you got to hear, and then when you're done with it, it goes over either to ethics or to the district attorney or the attorney general or the board of supervisors, but inevitably it's ethics because those other three offices aren't all that interested. But it's still a long fight, and if you really want to see the records, you're not sure what the outcome will be, and particularly before ethics, which I will discuss later because I think that's also part of the problem. The third problem is that the city attorney, I've now been jousting with the city attorney for 5 years over public records. There's a lot of stuff you don't even hear about and you don't see. But let me tell you that they will take the simplest, most direct request and convert it into some exemption. Believe me. And it takes a lot of effort and a lot of legal expertise, which I happen to have and which very few people do have, to pry it out of them. So where else are they going to go? Well, the simplest would be to go to the supervisor of records, because if the supervisor of records were just doing an honest, straightforward job and was not being influenced by her peers in the city attorney's office, who by and large advise departments on how to keep records exempt. They give them oral advice, which you never know about. There are any number of ways in which stuff becomes either work product or attorney-client privileged or you name it, and you never get to see it without doing something. So if the supervisor of records is going to end up being just like another deputy city attorney, it's not going to really help the average Joe. All I'm suggesting is that there be a standard, that the standard be that doesn't have an ethical wall, doesn't have but that it be a good faith, independent review, and that it take into account the rulings of this body in the process. That's it.
Member Washburn?
Well, I'm finding what Mr. Grossman says to be quite compelling. And, I mean, I see there are two sides to this issue, but I think that it's incumbent on us to make sure that it's the public's interest that is guarded here. And our ordinance is the law in San Francisco. We are the body that enforces this law. I think what we have ruled and should carry weight in this area in particular. So if there's some way to capture that without micromanaging this person's job, I think we should do it.
I mean, I don't think we're going to ever achieve what either you or Mr. Grossman want, which is, other than creating a fully independent body, which would require a new staff position, new people, new training, new ethical walls, we're going to get a truly independent person. I think, and I don't think it's actually good policy. I think it's important that the supervisor of public records be, a way of someone to get the city attorney's opinion on something. That's the purpose. If what you're suggesting, what I hear Mr. Grossman suggesting, is that a minimum, we should just put in that the supervisor of public records shall conduct an independent review of the matter raised, taking into account any prior rulings of the task force on the issue. I think we can put that in the ordinance. I don't think that's really going to achieve what either of you want, but I don't have a problem with putting that in. The question is where and how. I mean, that's really we're down to nuts here, nuts and bolts. So, I mean, that's what we really need to figure out. Member Johnson?
Are we talking about our orders of determination on something?
No.
If it's in conflict?
Well, we are saying you should look at the task force's prior rulings on issues. Yeah, so that would be in an order of determination.
So, ours are going to be listed.
I mean, that's just it. I mean, our determination are listed on our website now. They're not really annotated. I mean, the problem with this is saying, well, how is the supervisor of records supposed to know what the task force has found? I mean, they're a different body. They're out there. I'll put the language in, but it just seems to me...
So when we make a determination that is against or in conflict with another department, is there a way that we can memo that on our website? Would that be helpful to the public?
I don't know. I don't think it needs to be in the ordinance necessarily, but I mean, what you're talking about is a lot of administrative work. I mean, we should have orders of determination in a way that can be searched and utilized. I don't know, you want a separate category that says orders of determination that conflict with the departments, orders of determination that haven't been complied with.
No, I think
Right.
that simple language that you suggested that
Oh,
you
yeah.
could live with, I think would lend some integrity to what we do, lend some additional heft to what we do. I mean, we are responsible for enforcing this ordinance, and to do that well, we need to afford ourselves every opportunity to do so. And so the supervisor of records is a gatekeeper, is somebody who is going to be very helpful or not to a member of the public. But I think that person should inform the member of the public the status of the law and how it's interpreted in San Francisco at a particular point in time. So I think that, having that language in there would make that intent clear.
I'm right now trying to figure out where in the old ordinance the creation of the supervisor of public records is. I believe it's 6721C.
It's F on page 49.
I meant in the original ordinance.
Oh,
Current ordinance.
that.
Right, it is here. I just wanted to make sure. It also is here's the issue, folks. It also is in the new 6718. So,
Right. And when I was reading that, I had the same idea. It occurred to me, are we abrogating our role in letting someone interpret the ordinance?
the idea is to have another person, someone different from us. That's the whole purpose of it. You don't have to come to us. You can go to them. We may disagree, but it's more opinions, generally speaking, are better than fewer opinions. And this provides a very unique ability of members of the public to get an answer from the city attorney's office on a legal issue or a
Well,
factual issue.
the thing is, Erica, this job is not for the city attorney as a body. It's for an individual who is going to recognize a responsibility to the person that comes to the supervisor of records. And if you want to depend on the city attorney's office to be a part of your enforcement apparatus, just forget it. It's not going to happen. It's never happened, and it's not going to happen as we go forward. And another thing that I find very difficult is the notion that the city attorney has a greater authority to rule on these questions after you've ruled, because number one, the task force is a very special body. It was made under an ordinance, a law that is really the equivalent of the city charter. It has the same dignity, it has the same status, and your findings are probably more important in a particular case than the city attorney's. And what you're doing is you're turning that upside down. You're giving the city attorney more authority to deal with issues that you've already resolved than it should be the other way around. So I just don't understand it. Why Paul Zarefsky's memorandum, which has been disavowed and rejected in every case now, is going to be the standard by which the supervisor of records decides whether I get a PDF copy or an electronic copy. I just don't understand it. I'm not going to make any more of it. If you don't want to do it, it's okay with me.
Mr. Grossman, I think we've accepted your language. The question is, where do we put it in? The issue is, we're not creating something here different. It already exists, okay? It's there. The system is there. This is how it's functioning. And we may disagree about whether it's functioning correctly, or we may recognize there's some situations where we're going to disagree with the supervisor of records, but that's how it exists now. The question is, what, if anything, do we want to do for the amendments for the future? And if you want to create a wholly new body, then that's one way of doing it. I don't think we should. if you want to incorporate language into the existing provisions that says the supervisor of records shall conduct an independent review, taking into account prior rulings of the task force on the issue,
Yes.
then we can do that. We can put that in. I don't
Yes.
think there's a disagreement here. The question is now, where? Okay? So let's all just keep calm and figure out how we can achieve what's best within reasonable parameters.
Madam Chair?
Yes, member Nee.
Just off the top, I would suggest somewhere in new 67.20, I guess it's F, which is where it's already discussed.
Right.
Let's not forget about 6718, which also deals with the supervisor of public forums. So, I mean, that's the first place it should go. And then it should go also, whatever language we choose should go in both.
Both. I'm fine with it.
What I would suggest is on new 6718, which is on page 44, that we shall put in third sentence, in between the second and third sentence. Second sentence is on line 9. The supervisor of public forum shall inform the petitioner as soon as possible and within 10 calendar days of its determination on whether a violation occurred. In reaching this determination, the supervisor of records shall conduct an independent review comma, taking into account prior rulings, if any, of the Sunshine Commission on the issue. Member Johnson?
Would it fit nicely on page 49, line 19 also, where it's underlined of its determination, reaching its determination, independent review, just
Right.
exactly.
It should be, right, and it would also be inserted on page 49, on line 21, between the second and third sentences. So before this determination shall be in writing. So that's where the other insert shall go.
This would be after this determination shall be in writing? Is
It's
that what you're-
before.
Before.
In both instances, it would be before. Mr. Grossman, did you want to make a comment?
Well, I was going to give you a couple of edit changes, not in that section, but in I.
Under 6720?
Yeah.
Okay.
In H, you notice you deleted the word documentary and information.
Microphone, please.
And substituted,
Microphone, please.
pardon.
Use the microphone. We couldn't hear you. Please use
Okay.
the microphone.
I'm sorry. Page 52, line 16, there was an edit change. The same edit change is probably required in I, line 21, because that phrase documentary public information is used. And again, I think in on line 5 of page 53. It's in a number of places. I just suggesting that you do it for consistency of.
Where was the third place, Mr. Grossman?
On page 53, it's in line 5.
Actually, what I would suggest is, this is what I would suggest. For H, I think this is a good point. For H, it should be release of public information, because it can be documents or it could be electronic, which is not really documentary, right? I mean, that's the issue.
Well, a record is information in any media,
Right.
and record and documentary suggests a particular kind of media.
Right, we're going to remove documentary, but if we just say release of public information, but I guess the point is,
Well, it says whether for inspection or of the original or providing a copy. I mean, if it's just public information that is not in some media, then it can't be inspected.
right, well, I mean, the issue is, public records, and public records is defined as the Public Records Act, same definition, which,
Yeah,
as Mr.
which
Grossman
is-
points out, it includes information basically stored in any media, not just documentary, but it could be electronic, et cetera. So if H then is release of public records, then I should be inspection and copying of public records. And same as on line 5, inspection of public records. What I didn't want to do is, by using records, was to remove the access to, documents in any kind of a media, But I think that it's the way it's defined in the Public Records Act, it's broad enough to make it clear that it's basically information just stored in some format. So, I mean, we don't want to go too far. So I appreciate that. Anything else on 6720? Member Washburn?
I actually missed this earlier. This is an editorial issue on page 47, line 13. We have U.S. Mail with a capital M. I think it should be U.S. Postal Service with a capital P and a capital S. I believe the name of our postal service is USPS, U.S. United States Postal Service. It makes it look like U.S. Mail is the name of this entity that brings our mail to us.
Well, would you prefer we leave it as postal delivery or hand delivery? That's what it was.
U.S. Mail hand delivery. Or
US
no,
Mail,
U.S.
comma.
Mail is a separate.
Postal or hand delivery.
There we go.
So it should read
Right, because it could come by
fax,
FedEx.
postal or hand delivery, email or other means.
Mm-hmm. Yeah, that's fine.
You clear on that? Okay. Thank you. All right. The next changes that I suggested were to new 6722. Yes, Member Washburn.
I actually have a question about 6721. And I've read all this numerous times, and in reading it today, this is lines 19 through 22. Notwithstanding the 10-day period for response, a written request for information shall be satisfied no later than the close of business on the day following the day of the request. In reading this, it looks like that's to any request, not just an immediate disclosure request.
But the next sentence is, this deadline shall only apply if the words immediate disclosure requests are.
Yeah, that's confusing because the first sentence seems to say that any request should be satisfied no later than the close of business on the day following the day of the request. And then it says, but this deadline only applies if the words immediate disclosure request are placed across the top.
I mean, this is existing language, actually. It's not been really revised. It's just been replaced. So this is what the ordinance currently says. We just
Right.
have broken it out in a new format. So to me, it makes sense. Because it's only for information described in any category of non-exempt public information, right? So, I mean, it does specify the type of information. And then we also say, what is new is we say immediately disclosure requests are appropriate for records which are readily identifiable and maintained by the department or policy body in its active files. Request to inspect or for copies of documents that must be gathered is not appropriate. So,
Right, I understand that. It's just, I don't know why I'm having problems with this, but the first sentence seems to say that whenever anyone asks for some information, notwithstanding this 10-day period, it says the written request shall be satisfied, meaning that no later than the close of business on the next day. So it's seeming to say all requests should be satisfied no later than the next day, but this deadline shall only apply. See what I mean? It's like there's a 10-day period for a response. Okay, I think that's fine, and that's the law, but then this deadline of the next day is only for immediate disclosure requests.
right, for non-exempt information.
So I'm wondering if that first sentence could be edited so it's, notwithstanding the 10-day period, would be great if the information could be supplied earlier than 10 days. But it makes it sound like if, there is this 10-day period, but the request shall be satisfied the next day. Does anybody else have problems with this?
I do, but in something different.
Oh.
There are other provisions that require documents to be produced as soon as they're available, so they don't take the full 10 days.
Well, no, I
That's
think
somewhere
that's
else. Yeah.
important to convey that.
Right.
But it seems to be a sentence that's negating itself. It's saying, notwithstanding this 10-day period, these requests shall be
Right.
satisfied no later than the next
this
day.
narrow category of requests shall be satisfied the next day. And here's what you have to do to fall into that narrow category. You have to say immediately disclosure request. You have to say ask for records which are readily identifiable.
Right.
And you cannot ask for these other.
No.
So that's the way I read it. I don't see the problem. I guess I'm missing it. I mean, it's not grammatically perfect. I will give you that.
No,
We
that's
probably
not
could do
that's
it
not my
differently.
issue. There's nothing grammatically wrong with it. It's just that, somebody coming to this without understanding
Yeah.
all of different categories would read this and say, okay, there's this 10-day period, but this sentence says that my request shall be satisfied the next day, no
If
later
I
than the next
comply
day.
with the following three things. I have to comply with the following three things in order for it to be an appropriate immediate disclosure
Well,
request.
Well, right. I see that. It's
Yeah.
I don't have a problem with that part. And
Well, first of all, one thing we can all agree on is that line 20, it should be 6720C, not 6721. This is one of those things that we're going to have to be very careful about.
couldn't we change shall be to may be?
No, because we're saying if it's appropriate immediate disclosure request, you should have to comply with it. Shall is what's required.
Well, the next sentence says that. For all requests, they may be satisfied the very next day. But there's this particular category that has to be.
No.
The
that's not
deadline
what-
shall
That's
apply.
not what we're saying. What we're saying is a written request for information described in any category of non-exempt public information shall be satisfied no later than the close of the business day following the request when the following occur. 1, shall be immediate disclosure requests. 2, shall be records which are readily identifiable. 3, I mean, we don't break it out that way, but that's the point.
Perhaps to make it easier for the public. The non-exempt public information is in 6720C, correct?
No, what's in 6720C is the 10-day deadline.
Okay, maybe we should reference what exactly is, or direct them to what is non-exempt.
That's too hard.
Too hard.
You'd have to go into too much detail to explain it.
I would just know. Are we referencing it? Because if I was reading this, then I would be like, okay, what's exempt? And I'd have to look up
You'd have to go back.
what is exempt.
Right, well, there's a number of different provisions on that. Maybe Mr. Grossman can help us.
I'm not sure I can help Ms. Washburn's point, but I will give you a real-world experience. An immediate disclosure request requires the public records essentially the next day. What typically happens is that they ask for the 14-day extension. So instead of getting it within 10 days, if they had made a normal request, they now have to wait 4 more days simply because they made an immediate disclosure request. I recently made an immediate disclosure request to the planning department for certain records, and I got a response that the records were so voluminous that they had to invoke the 14-day rule. I said, well, then give them to me on a rolling basis. I didn't get anything on a rolling basis, and at the end of the 14 days, I got 2 files of about 3 pages each. Okay? Now, what can I do about that? Very, very little. So my question is, why is the 14-day period there at all? You can go back to the 10-day period if they have a voluminous file, because they can't invoke, I don't think they can, since it appears to me that this is part of the immediate disclosure request formulation. If they can't get it immediately, then give them the 10 days. But why give them an extra 4 days? That's my point. Laboriously. Thank you.
I think Mr. Grossman raises a good point. The issue here really is that C should come before B. The 14-day extension is really for an extension to the 10-day period. I mean, that's the way it's conceptualized in the Public Records Act request itself. I mean, the Public Records Act. If you've got a time frame for responding, if that's not going to be sufficient, you can ask for up to 14 more days to respond. So that's the genesis of this section. I see what you mean, that the way it's placed in here makes it seem like if you can't comply with the immediate disclosure request, you get 14 days more, as opposed to really it should be at a minimum 10 days, and then if you still need more time, you can do a 14-day extension. So I see that point, that it doesn't really make much sense the way that it was initially drafted. We've copied this, basically we've copied this section, we've just placed it here.
Well, there's always been a debate on the fringes of the task force about the 10 versus 14, because the initial reference to the California Public Records Act that was in the ordinance was wrong. They changed the rule in the act, and then you had a reference to a provision that had no relevance.
Right.
So the question here is, you have, when I say you, I mean the ordinance can provide for a period as short as 3 days, and you won't violate any law, because you can call for more expeditious public records disclosure. That's permitted under 6553E of the Public Records Act. And there's no reason to give anybody 14 days if 10 days is what you decide is an adequate time. That's all.
Right, I mean, I agree with that. And it's interesting to see that's how it's been interpreted. Yeah, essentially, under the Public Records Act, an agency has 10 days. And then if the agency needs additional time, it can give written notice and get 14 days more. So that's the way the state law works. And so that was what was meant to happen here. Immediate disclosure requests are in addition, as Mr. Grossman points out, it's beyond what the Public Records Act requires. And what we wanted to do was say, for these readily identifiable pieces of information, like most of what Mr. Warfield wants, right? He goes up to someone, he's like, I want this one document. You know what this document is. I know what this document is. That document is in your computer. You can press print and I can get it. That is appropriate for an immediate disclosure request. There's no reason why it shouldn't be responded to within the close of the next business day. So what I would suggest doing is simply moving B and C. And so you have maximum deadlines provided in this ordinance are appropriate for more existing or demanding requests, but should not be used to delay fulfilling a simple routine, otherwise readily answerable request. Then B would be C, the voluminous nature of information requested, its location in a remote storage facility, or the need to consult with other interested departments warrants an extension of the 14-day period as provided in Government Code Section 6253C1, which I believe is still the right reference. Yes. The requester shall be notified as required by the close of business on the business day following the request. The requester shall be notified as required by the close of business of the length of the extension, the reason for the extension, and a summary of the search method and results conducted to date, justifying the extension. Now that last part is new. It's very confusing. So that should really be in B. And then B should be C. This doesn't address Member Washburn's problem, and C is, notwithstanding the 10-day period, a written request for information shall be satisfied no later than the close of business day when it complies with the following three things.
I think switching that does help my understanding.
Okay.
Switching those two sections.
All right. Well, I think that's an excellent point. I hadn't even spotted that. Member Johnson?
Mine is just a consistency thing, where within what was B and now C, page 55, lines like 1, 2, 3, 4, 5, all the way down to 7, we say records, we say information, we say documents. Maybe just for consistency's sake, since we've redefined what a record is in any media whatsoever, even like emails or whatever, that maybe that would be better than saying documents. But that's just a consistency thing.
Yeah, I mean, I think we should leave it as B unless there's a specific reason that we want to change it. Just because it is inconsistent. I mean, this is one of these things that I was hoping someone would help me with, go through the whole ordinance and look at this, but no one has done it to date. I don't think it's a real problem. But I think we can leave. I don't want to do further damage to it. Member Washburn?
I have a grammatical problem. Line 2, page 55, there, which should be that. Immediate disclosure requests are appropriate for records that are readily identifiable.
Okay. There's a lot of witches in here. We've got some of them, but not all of them. All right, so are we agreed and can move on? All right, 6722. This is production of incremental rolling basis. This has been broken out. It's not new language. It's just been broken out. The last sentence on page 56. I think we should remove that. That was added by Member Comstock. back when there was a big debate about how much it was costing the departments to comply with the Sunshine Ordinance Task Force, Sunshine Ordinance, versus, Public Records Act requests, because a lot of it's duplicative, right? I mean, a lot of the Sunshine requests are actually public records requests. It's just that the Sunshine Ordinance has expedited procedures for responding. Occasionally, the Sunshine Ordinance requires departments to respond with documents that would be exempt under state law, but under local law they have to be produced. So I just think that there's no real reason to have this. What it does is it adds a huge amount of burden to the city people responding to keep track of this sort of information. That's unnecessary. I just don't think it really helps. I think it actually is a big problem. I mean, if the city's getting thousands of public records requests a day, requiring this does, to me, adds burden and doesn't achieve anything. I mean, it's the duty of people to respond to Public Records Act, full stop.
Yeah.
Mr. Grossman?
That's the law, too.
Right, it's the law. So why do we, I mean, other than purely interest, why do we care how much time and cost it is to comply? I mean, it's the requirement of the law to comply.
And I'll just add another comment. Having a lot of real-world experience making requests, a lot of the problems are because they won't create electronic databases. They're still in the 19th century in the record keeping. They don't follow their own retention policies. So, and then they blame it on the requester.
So I, without objection, would think that line should be deleted.
Yeah. Erica?
Yes.
Line 19, on page 56, inquiries, I think, should be spelled with an I, not an E.
I have that exact change as well. It is inquiries, not enquiries.
Right.
Thank you. And also, I have other suggestions for that same section, line 21. It should be, we should replace his or her with not disruptive of the employees' operational duties. Of the employees, apostrophe S, operational duties, and confined to requests for, as opposed to accurate, it should be requests for information not confidential by law. Any other suggestions for 6723? $67.24. B. Very important issue. I'm not sure how we missed this one. On line 21, it should be the identity and contact information of the sender of any letter or communication shall be presumed to be public information. Sure. There's been a debate about whether or not the contact information, the name, the identity and the contact information of individuals submitting testimony or comments or requests to members of policy bodies should be disclosable. we've consistently ruled that both the identity and the contact information should be generally disclosable unless there's been a request for confidentiality or if the person's a whistleblower or fears retaliation for having their identity or contact information disclosed. And this basically would clarify that that's the requirement. Yes.
Can I ask one question on that?
Yeah.
You recall the library, the case involving people who contribute to the library and the fact that they wanted their identity concealed?
Right.
What this would do is make it possible for them to decide that rather than whether it's in the best from a public policy point of view that their identity be disclosed. Obviously, you know, if the people who are doing work on a branch of the public library want to get more business, they just give money to the library, you know, in the hopes of influencing the decision. And I think it's important that there be certain exceptions. That's all.
Right. I think that's right. And that's, I think if you didn't allow anonymity in some situations, you'd have a problem. I think the public library would hate to see a rule that all donations are all have to be public, but there are other state rules that govern this. And if someone's giving a donation and request for doing city business, there's arguably other requirements that would require them to disclose that. So, all right. Any other comments on 6724? Excuse me. All right, 6725. Public information that must be disclosed. C2. Line 18, it should be, instead of city commissioners, it should be other policy body. City commissioners doesn't really make much sense. It could be a task force. So, I mean, if we say or other policy body, that would include all policy bodies, which I think is the intent. There could be a new, I guess my point is there could be a new name for a policy body that's not commission or task force.
I'm wondering, do we want those to be capitalized, though, a department head or city commission? Should those words be capitalized?
I defer to my grammarians on this panel.
I don't think they should be.
So, department head and city commission, please make lowercase. What about task force?
They should not be. They
What
should
about,
not be.
What about task force?
No.
Lowercase as well?
Yep. We're
All right.
talking about any one of,
Yes,
a
all right.
generic
Let's
term.
do it.
Yeah.
I would leave city uppercase, but except for that, because
Are
the
they
city
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 commission?
here is
It is.
here is referring to, an official.
All right, so city commission, city will remain
City
capitalized.
City should always be capitalized. Yes.
Okay,
Some people like to capitalize the too.
I know. Thank you. All right, 6725C8. And this needs a little bit of a fine tune because what I had suggested prior it goes beyond, I think, what we really need. So I would delete my prior suggestion of, and there is a reasonable cause to believe the complaint is well-founded. I don't think that's necessary. I think if we just have the allegations are substantial as distinct from baseless and trivial, get you the same point. And then in the second sentence, I think it's very important to put in an investigation or report regarding allegations of employee misconduct, whether or not the MS is conducted by an insert or at the direction of an attorney shall be released. And this is a very big issue. We just had this issue before us at the last meeting. And it really is just making clear that as far as San Francisco is concerned, where there's been an investigation into employee misconduct, even if that investigation is conducted by a city attorney or at the direction of an attorney, once that investigation is concluded, that report should be released. The public should be able to know what was concluded in terms of the factual investigation. So I think that should be included. Various cities have claimed that reports conducted under the guidance of an attorney should be also excluded from production, and this would just make it clear that that is not a basis. All right. 6225E1. This is to make. I found that there were some omissions here.
Yeah.
Very small ones. We have to put quotes around RFB and submit and similar requests after RFQ, and there should be a comma after the date of issuance. On page 64, lines 5, 6, 7, and 8, or 5, 6, and 7. Without objection? E8. On line 21, it should be along, not alone. And we need to delete, that's on line 21, and then we need to delete on line 23 the word that. Should be unless the policy body finds and articulates how the public interest. Okay.
Oh, what was that last thing? Where?
Line 23, delete that. 6725I for some reason is still in there. All withholdings of documents must be based on express provisions. That does not belong there anymore because that's about withholdings. So that sentence should be moved to be the first sentence of new 6726, which is withholding kept to a minimum. Which deals with withholdings. Okay? Are there any comments? Does anybody have any comments on 6725? Okay, 6728 is prohibited bases for withholding. For some reason we missed this. We wanted to put this in and it didn't get in. But I'm not, actually, I might have gotten that wrong. I think that, hold on a sec. Let me think about this.
Madam Chair,
Yes.
are you referring to 6728 or 6727?
6728. 6728, justification of withholding. Problem is, there's already a D there. That's what's holding me up. Not sure why I missed that. So, so it really should be a new E, not a new D. And it should be if any information is withheld under sections A through D above, the written justification shall identify a general description of the withheld information, the number of documents, pages, or lines of information withheld, and provide a general description of withheld information, and clarify that specific justification applicable to each piece of withheld information must be provided. This was basically to require, and this is a significant issue, but I believe we wanted to put this in, but somehow it got taken out, I think inadvertently. It's basically this is a big issue. Requiring folks to say, if you're withholding, tell me how much you're withholding. A lot of times they'll say, oh, we're withholding attorney-client privilege information. And you won't know, well, is that like a 10-page memo? Is that an email? Is that, a 50-page report that was conducted by an attorney off-site that really shouldn't be withheld? I mean, people don't have an idea of what's being withheld and why. And so this would require the department to just, when they're saying, hey, we're not going to give it to you, but here's why we're withholding it, and here's how much we're withholding, and here's the general nature of what we're withholding. Mr. Grossman?
I actually lost you. What section were you just?
It's 6728. New 6728 on page 70 is called justification of withholding.
Okay.
And this would add a new section D.
E.
Excuse me, a new section E. Thank you.
Well, where's E?
It's not there. It's in my suggestions.
Oh, okay. Well, I agree with your suggestions.
Yeah.
Very much so. I do have an anomaly to call to your attention. I made a request to the Department of Building Inspection to inspect some plans for a new building, or for renovation, actually. And it took them a while to get them to me because they were at some vendor being put on microfiche or scanned into the database. But when I finally got to see them, I decided I only wanted a copy of one page, the first page. So I asked the person, I'd like a copy of this. She said, you can't have it. I said, why not? She said, you need permission of the architect. So I said, okay. So I went back and I tried to find it, and finally I called her and I said, well, I can't find anywhere that you can withhold a public record on the basis that you needed somebody's permission. You need an exemption. And she said, well, there is one. And I said, where? She said, in the Health and Safety Code. And I said, huh? The problem being that here you only allude to two laws, the Ordinance and the CPRA.
Right, but the Public Records Act incorporates the Health and Safety Code.
It does? The exemption itself, or?
It does. It does, except that I believe that I've almost litigated that very issue. And my analysis is that Department of Building Inspection is required to provide a copy without the architect's express permission. There's a debate about what size that copy has to be. Most city agencies or county agencies now will give you a copy, but they'll give you a reduced copy. The theory is that they don't want, architects don't want people to take their plans and be able to go and use them and build a house somewhere else and profit on their work. The reality is that looking at the plans, It's the same as copying them to a great extent. I can go in and look at them and then copy them myself. And the other issue is that members of the public should have access to full-size copies of these plans, especially where height and grading are issues, because reduction compromises
No,
the scale.
I understand that. I didn't want a copy of all the plans. I only wanted one page.
Right.
It had no plans on it. It was
Right.
the cover sheet.
Right. I
In
mean,
any case, I thought
the argument is whether or not that code prohibits, the Public Records Act does allow reference to other prohibitions, to other exemptions. The question really is does the Health and Safety Code prohibit giving a copy in that case? And my argument has always been no.
Okay.
Anyway, that's an aside. Interesting you've addressed that issue. Okay, so 6729, fees for duplication. This is where we've attempted to consolidate and make consistent all of the fees for duplication. B, this is Mr. Warfield's issue. It should read, for documents routinely produced in multiple copies for distribution, e.g., meeting agendas, commas, agenda packet materials, and other public records prepared for consideration at a public meeting, unless a special. So that's the first change. At the end of this existing sentence, I would also add the following, which we had deleted from, actually I would add the following from F. Neither this section nor the California Public Records Act shall be construed to limit or delay the public's right to inspect any record required to be disclosed by that act, whether or not distributed to the body. This is from old F, I should say, not from new F. Sorry if there's confusion. But this had been oh, never mind. I'm sorry, I'm getting myself confused. It's the last sentence of F that's in here right now that shows it's new. It's not really new. It's just been moved from somewhere else. Neither this section nor the California Public Records Act shall be construed to limit or delay the public's right to inspect any record required to be disclosed by that act, whether or not distributed to a policy body. If we incorporate that into B, that sentence, then we can delete the rest of F, because the rest of F is simply duplicative.
Madam Chair, are you suggesting we move it or just put it in both sections?
No, we move the last sentence and we delete of F. I'm talking about we move the last sentence into B and we delete the first sentence
In B or in F?
in F. Because if you look, the first sentence of F is duplicative of the first sentence in B. Member Washburn?
I have a couple of small edits. Page 71, it's in B, 6729. B, line 14, there should be a comma after EG.
Mm-hmm.
Then on the next page, 72, line 5, there should be a comma after IE, and tape should not be capitalized.
Okay. And actually in 6729E, I don't know what this is hanging out there for. It doesn't make any sense. But $10 or less per meeting should be deleted. Should be the exact copy of the medium, and most of those mediums are less than $10. I'm not sure what that's hanging out for, but that should just be deleted. It doesn't make any sense. And as I noted on my list, number 17 is new 6729F can be deleted. because the second sentence was incorporated into B. New 6730, I think we did a lot of good things here, but I think we need a new A6. One of the things that we did not reincorporate when we moved was the prohibition that nothing in this section shall be construed to permit an agency to make information only available in an electronic format. Some people want an electronic format. Some people, I may not have a computer, so I may want electronic records produced to me in paper. And that just makes clear that the agency shall not be forcing requesters to accept electronic records where they don't want to. And again, that was in there before. It's just that when we moved around and consolidated, we somehow missed it. 6730B. Line 7, we need to delete 2. It should be shall, if requested, and if necessary technology and equipment are available, transfer documents. So 2 is unnecessary. Insert a period after electronic format. And then I would say the final sentence should read, the electronic format shall, as reasonably practicable, be searchable and electronically archivable, deliverable, deliverable via electronic email or other electronic means, and posted on the department or policy body's website as appropriate. Otherwise, it didn't really make any sense before, so I tried to make it make more sense. And it incorporates some of the comments that Mr. Crossman has made to us, that these systems, documents should be being put on a system in a way that's archivable and searchable, as opposed to a PDF that's locked that doesn't allow the web crawlers to look at it. So that's the purpose of that language. 6730 D4, which is minimum internet and website standards. Uh, 15. It should be past, not post, I believe. Well, maybe not. I don't know. Do you think it should be post? I was wondering about that.
Yeah.
Okay. That's fine. We can leave that then. Ignore my comment. Yes.
Yeah.
Right. Each department and policy body's homepage shall contain a link titled Records in Sunshine to a page wherein the name, phone number, and email address of its custodian of records and its records retention policy and as reasonably practicable post. See, I would say, and as reasonably practicable, past Sunshine Ordinance and public documents requests and the responses thereto are posted. See? That to me makes the sentence read better. And as reasonably practicable, past Sunshine Ordinance and public document requests and the responses thereto are posted.
Okay, that's good.
Can I make one suggestion? Change
Yes.
the word documents to records in the line 15. Instead of public documents requests.
Yep, that's fine. Public records requests. Thank you. Um, 6730 D5. It's not necessary. We've already addressed that elsewhere. So that can be deleted, and then 6 can become 5. Specifically, that is provided for in 6714. and under Mercarimi's legislation, but also under our tweaks to it. The next couple suggestions are 6731 just needs to be deleted. That's already been incorporated. I don't know why it hasn't been deleted. It's one of these hangers-on. It should have been deleted long ago. So that whole next section should be deleted because it's been incorporated to 6730. Same with 6732. That should just be fully deleted because it's been incorporated into 6730.
Madam Chair,
Yes.
so the deletion starts on line 23, page 76,
Line 23, page 76. Yes.
through line 21, page 79.
Yes.
Thank you.
And that, all of that language should be in 6730A. Mm-hmm. That's where it all should be. We've gone over this in detail, and something happened with the tracking. It just got totally bollocksed up. I want to make sure that 6730A has everything we need. I think it does. Okay. Um, 6731 is mistakenly referred to here as 6733.1, records and correspondence. That should be, it's on page 81. That should be 67.31. I don't know how the numbers got messed up here. They totally got messed up in our tracking. Records and correspondence shall be maintained and shall survive tenure and transition of officials. Yes.
I was wondering about B, 6731B, about the Department of Elections. I have some familiarity with that department from work I've done for the league over the years, and I'm wondering why this is in here and why we're giving permission to the DOE to get rid of some of these records right after the elections, the results are certified.
You'd have to ask Prop G. That's been in there since Prop
Yeah.
G.
It's
I don't
just-
know why it's in there.
It's just very curious. I mean, I know there have been times when we have wanted to look at some of these records because we're interested in election integrity, and we've been told we don't have these things anymore. So, and this is just really curious.
If you have a suggestion of how it to be changed, then we should hear it. I didn't really focus on it because I haven't heard any complaints about it. No one's,
Right.
and it's existing language,
Uh-huh.
so we didn't really focus on it. It's underlined only here because it's been moved.
Right, and I wouldn't have noticed it otherwise.
Right.
I don't know how I missed this. I haven't had time to really think about it. It just struck me as odd that here we're giving permission to a department to destroy things after not a very long period of time, because the elections are certified fairly quickly. I mean, not immediately. It's a matter of weeks. And I don't know why this information wouldn't be kept longer. It's very curious to me.
Yeah, I mean, if you have a proposal, let's put it in there.
I don't have anything off the top of my head.
If you want to think about it
Yeah.
and think about what your group might suggest in light of your difficulties in
Right.
getting these documents, we can address that when it comes back to the full task force.
Okay.
But I mean, I think it's an important issue that we just hadn't heard about. So if you
Okay.
can focus on that and figure out what might make sense, both from the public's ability to review these records and also the city's ability to retain documents for an appropriate amount of time and not have to keep them indefinitely if not necessary, make a suggestion.
Okay.
Definitely.
Right. All right. Yeah.
For A, there's some more I wanted to do in A. On line 12, it should be, to make it consistent with the rest of the section, say, transition of the mayor, comma, elected officials, comma, or any department head. So delete members of the Board of Supervisors. It should be any elected officials. And then the last sentence, I think, should just be, it didn't make any sense. Was missing something. So what I've suggested is the mayor, comma, elected officials, comma, department heads shall maintain and preserve in a professional and businesslike manner all documents and correspondence, including but not limited to letters, emails, drafts, memoranda, invoices, reports, and proposals, and shall, it should be and shall disclose them in accordance with this ordinance. So, Chris, just to reiterate, because it's a little bit different than what I have in my memo here, it should be the mayor, comma, elected officials, and department heads shall maintain and preserve in a professional and businesslike manner all documents and correspondence, including but not limited to letters, emails, drafts, memoranda, invoices, reports, and proposals, and shall disclose them in accordance with this ordinance. Okay? Yes. Which I have in my notes. Okay. 6730, new 6732, which is calendars of certain elected officials. That should be, I don't know what happened there, but it should be 67.32. Yes, Member Washburn.
But what about
We'll get back to them.
the lobbyist on behalf of the city?
Those are going to be 30, those are going to be, if you look at what I suggested for the numbering, those just get renumbered to,
Oh, okay.
lobbyists become 6734, sources of outside funding become 6735.
Oh, okay.
Okay.
Gotcha. Yeah, all right.
Okay, so on page 85, in calendars of certain elected officials and departments, we've basically broken this out but added some substance in. It's probably going to be controversial, but that's another issue. Under D, we need to have in Such calendars are public records and shall be available to any requester 3 business days subsequent to the calendar entry date. Is what I'd have for D. And then what I would have for E is because what we did is we deleted that and we said they should be posted. But reality is that throughout the day the calendar changes, so we need to keep it separate. So whatever the calendar is should be available to the requester 3 business days subsequent. What I would do with electronic posting is to combine that new sentence in D that we have here on page 86 and E and say instead, to the fullest extent practicable, the calendars and information required by this section shall also be posted on the department and elected officials' website at the start of each business day. But each public official subject to this section is encouraged to post his or her calendars as far in advance as possible. So what that does is still keeps the requirement that if they're not posting it, they have to, even if they are posting it, they have to produce what actually took place, what actually was on the calendar 3 days after. Because you're in the situation where the ones on the website may not be accurate because things were canceled or changed on that day. So we want to have people have access to the real calendar within 3 days. And then in terms of posting, we want to say, to the fullest extent practicable, you should be posting this at the start of each business day, and you should be encouraged to post it as soon as possible. Because I know in other city officials in other cities, and government officials post their calendar a week in advance, and then change it as necessary. So we want to encourage that. Mr. Grossman, you have some comments?
Well, I only have one. I don't have to go into any detail about the debate between a Prop G calendar and the real calendar. I'm a little bit bothered that this doesn't actually say that the original entered calendar in whatever form, Lotus Notes, or whatever the, Microsoft version is.
Right. Can I interrupt you for a minute?
Is the calendar.
Yeah, I forgot to say. Well, I think there's a difference, because what this requires is that it requires certain people to do a minimum, right?
Yeah.
And what 6732F, I don't know how this is another situation. I thought this was in there, but when I went back and read, it wasn't. And I think it was something got dropped in translation, which is why this process is so difficult. We have to be so careful. What I need to put in there is what I propose under my number 27. Nothing in this section shall exempt from disclosure any calendar or calendar information used for official city business that is kept by any employee or official.
Okay. I would actually put that affirmatively right at the beginning and say every calendar maintained by, the following people shall maintain a daily calendar, and every daily calendar maintained by them in its original format with all original entries is a public record. As a minimum, those calendars shall contain the following. And then I would go through what they have. Because I don't have to tell you, this is a real hot issue. And
it is. The only problem with doing it that way is that I like it at the end because of the following. What I want to say is the calendar of Chris Rustum is a public record. But he's not required to keep one under this provision.
Yeah.
But if he does, that's a public record. And
Yeah.
that's part of the problem.
Okay,
And so
well-
what I want to say is that,
Oops, sorry.
here, certain high-level officials have to keep calendars. And here's what Prop G said you have to keep.
But I don't see the word minimum, and I don't see the word originally entered calendars, and that's what the fight is about. They say the city attorney's on record. It's all over the ethics cases involving calendars. They get advice from the city attorney that Prop G establishes the calendar, and therefore they can take their original entry calendar and recycle it into a Prop G calendar.
Right.
And then you miss whatever they don't want you to see.
Right,
And there's
but
no way to find it.
That's why That's what I tried to address in F. Nothing in this section shall exempt from disclosure any calendar or calendar information used for official city business that is kept by any employee or official. I
Well,
think it's pretty straightforward.
well, that's an issue of style, I guess, or how one would approach it.
Yeah, but I mean, I appreciate the comment because for some reason that should have been in here. And I know I had suggested it go in here and we approved it
Okay.
and it's not here.
Okay.
Which
I'd
causes me
actually feel more
consternation.
comfortable with the way I would do it, but that's one thing. I actually have to leave within a couple of minutes, so I'd like to take 2 minutes of public comment right now, or 3. Can I do that?
Does anybody else have any suggestions on 6732F or the remainder of Article 3?
A
Yes.
tiny thing, city attorney the should not be capitalized. Page 85, line 3.
Also, in members of the Board of Supervisors, the M in members should be lowercase. Also, on line 4, department and agency heads, those should be lowercase.
Okay.
I just have one last thing. It's some substance, and I haven't had time to think about it. But section about referrals and enforcement by the Ethics Commission, I was just...
We're not there yet.
Oh, I thought...
That's the next. I think Mr. Grossman's probably going to want to address that. But
Oh,
we're,
okay.
this is Article 3, so nothing else on Article 3.
Sorry.
All right, so we'll move on to Article 4.
Okay. Well, my comments are really more general, and it has to do with the importance of getting this amendment through. And of course, my focus has always been in 2 areas, the roles of the city attorney and the ethics commission. I mean, I've probably spent 70% of my time dealing with it because you cannot, using legal reasoning, statutory interpretation, or any other means, break through that cabal. The ethics commission gets opinions from the city attorney, not even in writing, and uses them as a basis to dismiss a task force referral. I've gone through this. The fact is that if you've looked at their proposed rules, the ethics proposed rules on how they're going to handle direct complaints, referrals, and official misconduct, they're all the same. They treat them as a single issue of a willful violation. They've lumped them all together, even though they have 3 distinct and separate tracks. Okay? So, and they're not going to change. So ultimately, if you keep sending stuff to them, you're going to get it back in the same fashion. So that's what's so important here. Plus, the other thing that I want to stress, and I've been saying this for a long time, and the more time I spend on it, the more I think it's important. The Sunshine Ordinance has been constantly downgraded by the city attorney because it says it's just an ordinance. It's not the level of a city charter. There are a couple things wrong with that. First, prior to the adoption of the current city charter, ordinances that were adopted, initiated and adopted by the voters were part of the charter. They actually were appended to the charter. So they had the same legal importance and dignity as a charter itself. That's number one. That's the first thing I heard. The second thing is that the Sunshine Ordinance Task Force is unique. There's no other body, no commission, you name it, in this whole panoply of commissions that we have in the city that has what you have, which is a special job. And the job is carefully spelled out, and what you do should have special meaning and effect. Otherwise, what does the Public Records Act mean? When you can do something at a local agency level and then have it basically trashed because it's just an ordinance with some folks sitting around trying to decide whether a public record is exempt or not. So that mindset has to be carried through to whatever you do. And when you get this thing passed, that's really an important factor. And my view is that your findings and your interpretations of the law should be binding on the Ethics Commission, not just capable of review or for an abuse of discretion, because you've already done all the work, you've heard all of it, and that's your job. And if they're going to just say, it may be a higher threshold, but I don't give Mr. St. Croix and his compatriots less credit for not finding a way around what you do than they already have. They're going to do it because that's their mindset, that's what they want to do, and the 5 commissioners are all political appointees. They're the very people that most of these requests are made to. You know, the mayor, the city attorney, the district attorney, and the supervisors. And that's all. Thank you.
Thank you. And we do have your comment on language, which we will add in, that you circulated, I believe.
I just realized there's probably 2 words that you don't need. At the end of the 3rd line, the word and the word penalties in the 4th line.
One more time?
The word and at the end of the 3rd line and the word penalties at the beginning of the 4th line.
All right, just take out and penalties. Okay. Okay. Thank you. And thank you for being here and giving us comments. The order of the contents of the table of contents needs to be changed, and I've laid that out in my edits, and that's just a ministerial thing. So I won't go through those tonight. We'll just authorize Chris to make those changes. My comments: replace commission with commission. That's not what I. Yeah. In this section, for some reason, commission is in all caps frequently. So we'll just authorize. Yes.
I believe I have taken care of.
You have? Oh,
Yes.
good. Okay. In the version I was reading, it still hadn't been taken care of. Thank you. So that's good. All right, then renumber all the sections, because all the sections will have to be renumbered given the new sections we have in 67 and Article 3. Okay, on substance, 6734C. Mayor should be capitalized on line 9, page 90. You Member Johnson?
Yeah, if we could just go back to page 89, actually.
89? Sure.
Yeah. Because of this is particularly the seat that I hold right now. I know that we were moving some of the requirements into a pool, so it would be easier for people to get these, have more participation. But the way that the ordinance is now, it has a minimum of 3 years experience in consumer advocacy. There's no minimum here, the way that you have it. And also, you changed consumer advocacy to obtaining public information, line 6.
Yes.
To obtaining public information from government agencies. I think there are different types of consumer advocacy, and it could be or including. And also on line 11, leave in and who has demonstrated interest in citizen access and participation in local government.
Okay. With respect to the 3-year, I don't see that in the current ordinance. Where's their 3-year minimum?
I didn't see it in the current one, but I just remember.
I don't think there's a minimum years for any of this.
Is it on the website?
Maybe.
No, it says experienced in consumer advocacy.
Right, experience. The idea was that experience in consumer advocacy doesn't really matter here. What really does matter, I mean, consumer advocacy could be, advising people on debt relief or advocating for consumers' rights in, false advertising cases. So we thought that really what matters here is what you want people who have had experience in obtaining public information from government agencies. But, how different is that from 4 members who demonstrate interest in or have experience in the issues of citizen access and participation?
True.
It's pretty much the same thing.
Or at least participation, yeah.
So, I'm not really sure what we accomplished by that change. This was one that was suggested, I think, by Member Comstock as well. Former Member Comstock. It's a little bit different because it's about obtaining public information. That could be the same as citizen access, though, right? If people, to me, it's almost more like 6 members shall have demonstrated interest in or have experience in the issue of citizen access and participation in local government, including obtaining information from government agencies. I think that would be the better course here, if that makes sense to people. Rick, do you follow that?
Sort of, but just at the start of the new 6734A, it says all members must have experience and/or demonstrated interest in the issues of citizen access and participation in local government. Why repeat it?
It's true.
It's just kind of identifying who they are. That's the thing. 2 members, it's additional criteria, which I agree with you, doesn't make much sense. That's the way it's been.
I just don't think it's necessary to repeat it. If it's stated right up at the top, all members.
It basically means 6 people can be anyone then. 2 members shall be appointed from the SPJ, one of them who's an attorney, one of who is a journalist.
Right.
1 member shall be appointed from the press or electronic media. 1 member shall be appointed from individuals whose names have been submitted by the League of Women Voters. And then basically 6 members fall into this other category. And then 1 member shall be
When possible.
when possible, an individual with disabilities. So it's 11 members. 2 from SBJ,
1 from LWV, 1 from New America Media.
1 from press or electronic media, 1 from League of Women Voters, 1 from New American Media, 1 who is disabled when possible. That's 2, 3, 4, 5, 6. 2, 3, 4, 5, 6. Right? These numbers don't even add up. What am I missing?
The member who
So-
has a disability could be.
Oh, that's any of the seats above.
Right,
Right, okay,
right.
that's what it is. That's what it is, okay. So the only designations are 2 have to be from SPJ, 1 has to be from press or electronic media, 1 has to be submitted by League of Women Voters, 1 has to be submitted by New American Media. So those are 2, 3, 4, 5 individuals. Then there's this other 6. The other 6 are just general. I
But-
guess the point is that we don't need to specify they're general. If we don't otherwise identify them, we can just leave it blank.
Like what Member Nee said, 2 members shall be members of the public experience in obtaining public information from government agencies. I guess that could just be deleted since line 22 on page 88 says all members must have experience
Right,
or
and-
demonstrated
And the
interest.
prior sentence as well.
Yeah.
That's the
so
issue. So,
we would just delete that. Would that be?
deleted is not necessary. I mean, it's not changing anything. I mean, the question is did the consumer advocacy add anything? I'm not really sure what it meant, or, I mean, I don't know, Rick, if you recall why that language was included in Prop G.
I don't recall.
I don't know why I recall there being a 3-year on but it's not in there.
I couldn't find it in the original one.
Just remember it being when I filled it.
All right, so anything else to that one?
So we're not making a minimum here.
No.
Okay.
Unless someone wants to, but I don't believe we need to. We haven't had an issue with it.
I don't have an issue.
Okay. All right, so we're basically deleting the 4 and 2 because it's duplicative of what was stated above. And we didn't feel that consumer advocacy needed to be called out because it's not necessarily relevant to what we do.
All right.
Okay.
Madam Chair, would that be line 3 through line 6?
Yes, that's correct.
Thank you.
Okey-doke. So 6734C, line 9, office of the mayor shall be capitalized. And the sentence that starts on line 18 and goes through line 22, I propose to make it clearer. Because the Ethics Commission has consistently ignored the fact that they are included in this section. So we need to call them out. This is one of the Alan Grossman's points. So it should read, the Commission may make referrals to a municipal office or any other appropriate body or official, including the Ethics Commission, the District Attorney, the State Attorney General, and the State Attorney General, with enforcement powers under this ordinance or under the California Public Records Act and the Brown Act, whenever it concludes that any person has violated any provision of this ordinance or the acts. So we need to include the Ethics Commission specifically by name because they seem to ignore that they're included already. Okay?
Yeah. Let's do that.
67, any other comments on 6734? $6736. B. We changed B. This is on page 93. To be, the city shall give no subsidy, money, tax abatements, land, or services to any, we had private entity. We put for-profit entity. I'm not sure why we changed that. But I think we just want to include, I think we want to go back private because private would include nonprofits, and otherwise nonprofits would be excluded. So I'm not really sure what we were thinking. Rick, if you can remember, I don't remember. But I think it reads better as including private. And then reinserting and agrees to in writing to provide and provides the city is the other change I would make. So I would take out for profit, leave private, and then leave agrees in writing, but put an and. What we wanted to do there was that a lot of times the concern was the party may, these people receiving the abatements may agree in writing to provide the city with financial projections but never provide them, which is why we deleted it in the first instance. But I think it's better just to say you're going to agree in writing and you're actually going to provide them. Um, 6739A, page 95. I just think because we've just been talking about the Ethics Commission in this section, we just need to say A is the Sunshine Commission. Shall conduct administrative hearings. And then And on line 4, it should be sunshine commissions as well, just to make it clear who we're talking about. We're on pages 95 and 96. We're just on line 19, we're adding sunshine before commission. And on 96, line 4, we're adding sunshine before commission. Just so we're just being a little bit clear here, because we start to talk about other bodies and commissions in this section. So where it was ambiguous, I thought we just needed to specify it a little bit more. 6740 D2. The second sentence should read, the commission shall include in its bylaws criteria for selection and oversight of appointed counsel and expenditures. The it comma makes no sense, so it should be in its bylaws. 6741. We need to delete by. The commission may also refer the matter, delete by on line 5. It should be just to the Board of Supervisors. Uh, 6742A5. It's on page 100, line 8. Upon referral, we don't need. We just should, the sentence should start, the commission may, in a referral of a finding of official misconduct. It's duplicative otherwise. 67A27. I think what I wanted to do there is
Sunshine Commission.
put the Sunshine Commission's litigation fund. We make sure we don't want it to go into the Ethics Commission's fund, so it should go in the Sunshine.
Line 12.
Line 13.
It's line 13, yeah. Shall be placed in the, any such fines imposed by the Ethics Commission under this provision shall be placed in the Sunshine Commission's litigation fund. We need to make sure that the money's coming to us, not staying with ethics. All right. 6743A, this is on page 101, lines 1 and 2. It should be respondent to prove with specificity that they've fully complied with the ordinance. And then the and, so request and should be deleted. It should be if they have fully complied with the ordinance or that an exemption disclosure applies. That's how it should read. Under D, line 15 of the same page, it should be prior to any action being commenced pursuant to subsection C. I've made that change like 3 times and it never shows up. It has to be C, or else it makes no sense. And that is it for me, except for one final thing that was suggested by Mr. Grossman, which would to be on in 67, where we are here, 6743, G, G, we should put in what Mr. Grossman suggests. I believe it's fine.
Madam Chair?
Yes.
Just a couple of small changes that I would suggest.
Yes.
After the word standards on the first line, put a comma. And then on the third line, since we are mentioning the Ethics Commission in the top line, in the third line I would put Sunshine Commission.
And then we're deleting and penalties, as Mr. Grossman suggested, on the fourth line.
Could you say that again, please?
Pardon me?
Could you repeat that?
Sure. On the fourth line of what Mr. Grossman suggests, we're deleting and penalties.
Thank you.
So it should read, the Ethics Commission shall apply the same procedures and standards, comma, and conduct such proceedings in the same manner and under the same rules as it would have conducted them upon a referral from the Sunshine Commission for enforcement of such order of determination pursuant to and in accordance with Section 6742. Except that the Sunshine Commission shall not be considered a complainant of record as provided in Section 6742A1. Okay, so Sunshine should go in twice there.
Can we revisit page 93?
The what?
Can we revisit page 93, Madam Chair?
93? Sure.
Yes.
Okay.
Which line are we adding the word and?
On line 5, so the first sentence should read, the city shall give no subsidy in money, comma, tax abatements, comma, land, comma, or services to any private entity unless that private entity agrees in writing to provide and provides the city.
Do we need a comma after provide to provide?
No.
Thank you, Madam Chair.
Does anybody else have any other suggestions?
I was looking through Article 2 earlier today and just found one thing that was a problem. Page 39, line 20, number 3. I'm wondering why it's all in caps.
Page 39. Where is this? I'm sorry?
Line 20.
Line 20, it said number 3 under C.
Page 39, lines 20. Where's the all caps?
The chair may allow a
designated
speaker.
It's all in caps.
I think it's because it was kind of conceived of to be as a heading, and then A and B and C describes it. You know, it's not like a paragraph. It's more like a new subheading.
But it's number 3 of, there's 1, 2, and
Yeah.
3 under C, and
I
this is number
understand.
3.
I
So-
understand. Yeah.
Although number 4 has capitals.
As well, right.
Right. But number 1 and 2,
It's because number 3 and 4 have subcomponents, and number 1 and 2 do not.
I see.
I'm not sure if that's the correct way of doing it, but that's kind of
I have no idea.
how we did it.
Okay.
But just while we're here on Article 2, I wanted to make sure I had mentioned this before, Chris. On page 44, line 5, it should be section, I believe it should be section 6720, not 6721. Did you note that? And then we incorporated the line that Alan Grossman suggested as well. Under line 10. Did you see that? On line 10, page 44, that's where, before this determination shall be writing, we inserted in reaching this determination, the supervisor records shall Remember?
Yes.
Okay. All right. So at this point, here's the status. I've gone over what we did last meeting. Chris has updated it and done the double underline and double strike through, showing what we've done. I went through that and found some things that were missed and things that need to be addressed, and I've given those to Chris to handle. And Chris, you'll do what I suggested, correct?
Yes.
Just make sure that you keep your document safe. Just compare mine to yours and make the changes. I will do the same for this. As soon as Chris is done with these suggestions that we've approved today, I will go through and make sure that those are correct. And then what we need to do is have that document reflected as, on the first page, Chris, it will be amendments for 2010. So this is on page 1. Finalized 6/12/2008 by the task force, and you can keep additions or single underline, deletions or strike through, and then you need to say finalized by C&A on 3/3. Additions are double underlined, deletions are double strike through. So that will be clear about what the system is. So you need to insert that there. But Chris and I will do that. Then we'll have the up-to-date version, and then it will be on to Member Nee to schedule a special meeting. Member Nee?
Yeah, Madam Chair, I was going to address that. I'd like to ask Mr. Rustin to investigate 4 dates. I'd like to have 2 special meetings of the full task force. We may not need to, but I want to schedule 2. The first one would be either March 30th or 31st, Tuesday or Wednesday. The second would be Tuesday or Wednesday, April 6th or 7th. So please check the availabilities, and then we can go ahead and schedule the meetings.
Through the chair, I'll check on that.
Yeah, they, maybe they wouldn't have to be at 4 p.m. Obviously, I think that's the preferable time, just because that's what we're used to. But if another time becomes necessary, I think we can try and work around that.
Through the chair, we can certainly secure this room, but if it is after 5.
Okay. Please let us know.
And then I will also, before that time, once Chris and I have agreed that all of the amendments all the suggestions that we've approved have been tracked, and they're consistent in the document, there's no other typos that need to be addressed, I will then go through and revise the annotations because they need to be updated. Some things have been moved, some things have not been moved. It's going to take me a while, but I'm going to go through and try to do that. And then the only other task that's left for me to do is kind of a summary letter. Unless someone else would like to help me with that summary letter, I would welcome the help.
I'd be happy to help with it.
Right. Well, why don't if you wanted to take a first draft at what some of the major changes are, what kind of the process we went through. What I would say is, we met with these people, we got comments from these departments. That was our process over the last number of years. And we've also, here are the summary of changes. If you could do that letter, that would be surely helpful. All right, so that's it for today. I appreciate everyone coming out and appreciate the comments from Mr. Warfield and Mr. Grossman. Thank you very much. This meeting is adjourned.
Regular meeting.